You guys set?
The live stream is down right now, but I'm recording. I'm recording. Okay, so you know.
Just give me a signal.
Okay.
Yeah, Mark, you can go whenever you want. It's recorded. We just don't have a stream. It's up to you. If you want to wait, that's fine. Close this out. Let's start.
Our link will stay.
Yeah. Just close it out and start. Yeah, the link is fine.
So, I'll just for the record, I'll introduce myself again. The name is Mark Fancher. I'm the staff attorney for the Racial Justice Project of the ACLU of Michigan. And the topic I want to address is one which is not for the faint of heart. It's dirty work because it concerns the issue of when and how police officers can or should be prosecuted for crimes when they engage in unlawful conduct. And it is a topic that makes many people in the law enforcement community wince. It is something that makes prosecutors recoil with in a defensive kind of a way many times, suggesting that they are in some way being attacked or insulted because there is a suggestion that they are not doing what they should do. And it's not about any of that. It involves a lot of things. First and foremost, it's just a basic question of accountability. We are living in a society which is driven and guided by a set of laws, rules, and there is an expectation that everyone across the board is going to abide by those laws and follow those rules and comply with them. And when you don't comply with the law, then there are certain consequences for them. And our country is famous for insisting that no one is above the law, that everyone is to be held accountable for their actions. And it creates a problem on a number of different levels when there are law enforcement officials who engage in conduct which is, at the very least, perceived by the public to be illegal or in other ways unlawful. And there don't appear to be any consequences for them. That creates problems on a number of levels. In one respect, it's problematic because it sends, or at least it creates the potential for a message to be sent to the law enforcement community that police officers are untouchable, that they are immune, that they can engage in misconduct if they want to and not suffer consequences for it. It sends a message to the broader community, or it has at least the potential to send a message to the broader community, that because of the fact that police officers are not held to account for their actions, that the police are not to be trusted. And that works directly against what so many of us have been working to accomplish, which is a relationship of trust that exists between the community and between the police. So it's an issue which cannot and should not be avoided. It needs to be taken on, and it needs to be grappled with, and there does need to be a resolution of the problem for those and many other reasons. It is particularly important during this period because of certain cases which have been highlighted so much in the public discussion and in the media and elsewhere. These are cases where the misconduct of the officers at least appears to be blatant. It appears to be, at least to the public, to have been an incident that involves a crime, and there have not been consequences that the average person would think should logically follow from it. Probably the one that has gotten the most national attention is Eric Garner's case in New York involving the chokehold, where in full view of cameras, he was wrestled to the ground and choked to death. More local and more immediate to us, and something which has been the focus of much of the ACLU's work, is the case of Milton Hall in Saginaw, where a 49-year-old homeless black man was standing alone in the middle of a parking lot ranting. He suffered from a mental disability. Police were called and 8 police officers arrived. They essentially surrounded him in a semicircle. One of the officers held a leashed canine. The leash was loosened, and the dog approached Mr. Hall while snapping and barking at him. Mr. Hall removed a pocket knife, waved it somewhat in the direction of the dog, even though the dog was still a significant distance away from him. And it was shortly thereafter that the other police officers raised their rifles and shot more than 40 bullets at Milton Hall. In the end, the county prosecutor, after reviewing the case, reached the conclusion that there was no basis for bringing criminal charges against these police officers. That decision alone would be a reason for concern, except that this incident, the entire incident, was captured live in a living color by the dashboard camera in one of the police officers' cruisers. And that footage of this man having been killed essentially by a firing squad is still available for anyone to see on YouTube if you have the stomach to actually watch that. The U.S. Department of Justice investigated this killing, and at the end of its investigation concluded that there was no basis for bringing federal criminal civil rights charges against the officers who were involved in this. Now, at no time should there be any suggestion necessarily that prosecutors, Department of Justice, or anybody are operating in bad faith. But there very well may be aspects of the law which do require a very close examination and reconsideration and possible adjustment in order to ensure that if there is not what we would not necessarily want, guaranteed prosecution of these officers, at least a shared belief that justice has been done, that their cases have been properly reviewed, and that decisions made either to prosecute or not prosecute are those decisions which everybody understands and which everybody can get behind. And we're not there because there are so many aspects of this which are problematic. In Ann Arbor, there was another killing of a 40-year-old black woman named Ara Rosser. In this case, she was also suffering from, or at least according to reports, suffering from certain disabilities, was on a rant and a rampage through her house with a knife. 2 police officers were called to the scene. And this is all according to police reports. The officers entered the house. They claimed that she charged at them with a knife, and she ended up shot by one of the officers. The other officers deployed a taser, right? That circumstance in and of itself raises lots of questions. Whether the law says that the decision not to charge these officers is one question, but there's another question in terms of the public perception. Because the standard that's very often used in these cases is what would the reasonable officer do under these circumstances? And in many cases, you're trying to measure a police officer's actions against a standard involving an imaginary police officer. You're trying to figure out, hypothetically, what would the reasonable officer do? In Ara Rosser's case, you had two police officers who were experiencing the same thing at the same time. And they reached different conclusions about how to respond to that, what was characterized as a threat. One of them chose to use deadly force. One of them chose to use less than lethal force. And so it creates many questions in the minds of the public about what should be done, what an officer should have done, how he should have responded. And it leaves a lot of people very unsatisfied with that result, undercutting the level of trust, not only in law enforcement, but in the prosecutor and the decisions and analysis that the prosecutor makes. So these are issues which we raise and which we think really need to be addressed. One of the things that we have suggested is that that there be a close look at and careful examination of the possibility of, in cases where you have a death, particularly with the characteristics that have been so problematic, you know, white police officer or police officers, victim of color, that there be the use of independent investigators and independent prosecutors. You know, that question or that proposal or suggestion has been raised casually with various prosecutors, and they really have, the ones that we've talked to have not been very receptive or very responsive for a whole host of reasons which they can explain for themselves. But from the standpoint of the community, if there is a prosecutor who is making these decisions, who is not dependent upon the goodwill of the local police officers, that at least creates the potential for greater trust in the decision that is reached by the prosecutor after they investigate and make their analysis. Because a reality in many jurisdictions is that prosecutors who investigate and make decisions about these charges against police officers know, and whether they actually believe this or whether they actually follow it, there is a perception that they are going to be dependent upon police officers in other cases that they choose to prosecute. And that there is no better way to alienate yourself from a police department and its personnel than to bring criminal charges against one of the ranks, one of its members, because we do know that very often police officers do stand united, you know, regardless of what the circumstances are. That's not all the time, but that is an observed phenomenon. And if it's not an actual phenomenon, it's certainly a perception that a prosecutor can have, a fear of retaliation or reprisal by the rank and file police officers if they go after one of their own. So that becomes a real dynamic. And so bringing somebody else in who is not dependent upon that relationship as between prosecutor and police officers is something that could be very helpful. You know, how that's done is an open question, because, you know, it raises many questions about who that would be. Where do they come from? How do you ensure that they really are independent and that they don't share the same commitments or values, or there's not an affinity between the supposed independent prosecutor and the one who's being replaced for that particular case? You know, those are things that would need to be addressed and need to be worked out, but they are a reality. With respect to the federal standard, federal criminal civil rights charges are brought under a statute that's cited as 18 U.S. Code Section 242. And the requirement in that statute is that the officers who are suspected of having violated that statute have, you know, to use the term, the language of the statute itself, they've engaged in a quote-unquote willful deprivation of the civil rights of the victim. Okay. With respect to Milton Hall, the Justice Department concluded that it was not making an assessment or a judgment about the culpability of the police officers or the merits of the case, but it based its decision on a belief that it would be unable to meet that very high standard of demonstrating, having enough evidence to demonstrate that the officers involved engaged in a willful deprivation of the civil rights of Milton Hall. Our response was to point to a U.S. Supreme Court case called Screws versus United States, which was decided in 1945, which held which acknowledged essentially that is a very difficult standard to meet, but which also held that in order to meet it, it's not necessary to demonstrate that the officer involved was consciously thinking in those terms. I intend at this point, when I am shooting this person, to willfully deprive this person of his civil rights. It was instead a suggestion that if a police officer showed a quote-unquote reckless disregard of the constitutional rights of the victim, that would be sufficient for meeting the standard. This case is a controversial one. The circuits, the appellate circuits in the country have split on it wildly. There are some which follow it and adhere to it. There are others that take it with a grain of salt and don't really believe that it means what it says. And they go with the stricter willful deprivation of civil rights standard. Obviously, we're of a mind that Screws should be used on any and every occasion when it would be appropriate to use it. But beyond that, what we are suggesting at this point is that as difficult as the willfulness standard is to meet with respect to the quantum of evidence that's required, as difficult as it is, the statute was drafted for purposes of use. It was not drafted and passed with the idea that we're just going to put a law on the books that really will never apply to anybody, that it's just there to take up space on a page, that it must apply to somebody. And there are cases, in our view, that clearly fall within the category of cases where the willful deprivation of civil rights standard clearly applies. Opinions may differ, but we believe that when you surround a homeless man with 8 guys with rifles, and he's armed with a pocket knife, and he's confronting a barking dog who's trained to attack, that if these officers basically empty their guns, that's one of those cases where there was a willful deprivation of this man's civil rights. And if a man is choked to death on a street corner for selling illegal cigarettes, and it's all caught on tape, everybody can see it, that's a case where there's a willful deprivation of civil rights. Now that's an opinion. And we suggest that there are never any guarantees of success in any prosecution, right? But there is within the authority and the ability of those who prosecute federal cases to make decisions to give it a shot. And ultimately, I think that is all that citizens can expect. That if you have a case which is so blatant, which is, in the estimation of most decent people, a murder that's been carried out by 8 police officers, that if charges are brought against these officers and the evidence is put before a jury, and a jury, after looking at this video record, and after hearing testimony, and after looking at evidence, comes back and finds these officers not guilty, no one will find fault with those who made the decision to bring those charges. Right? that all that you can ask is that when it appears that there has been a crime committed, that there is a good faith attempt to prosecute and to hold the officers accountable. And ultimately, the system has to work the way that the system works. Either these officers are going to be found guilty or not guilty. And whatever institutional factors there may be, whatever institutional barriers there may be, whatever impediments there may be, to making these kinds of decisions are things which we are very interested in trying to isolate and identify and to work through. Because we are not within the Department of Justice. We don't know how and why they are following this approach to these particular cases. But if there are recurring factors, if there are institutional factors which are leading to these kinds of conclusions, it would be very helpful to identify them, find them, address them, or at least to explain them, so that if it is a barrier which cannot be overcome, that we will be able to redirect our energy and focus to something that's going to be much more productive. So I'll stop there in case there are questions.
Very good. Very articulate. I just have a couple, kind of a question and kind of context kind of thing. Let's just take one of those hypotheticals. And as I talk about this story, I really want everyone in this room to picture it's your sister, brother, kid that is a cop. Your brother, sister, kid, mom or dad is a cop. So a couple of things about police training is edged weapons are very dangerous. And I guess where I'm going to go to is where do we draw the line to figure it out. But let's talk about the one where there's two cops, one has a gun, one has a taser, and a woman with a knife. So cops are taught that in this distance from me to you, your average person, a little bit of training with a knife, I can get to you before you get your gun out and shoot me, So that's one of the things that we're trained. The edge weapons are very dangerous. Depending on your close proximity, put something in between you, what have you. Another thing that cops are trained is that whenever there's less lethal, like let's say I got a taser and you look like, you might have a baseball bat, you look like it might be a physical altercation that doesn't look good, and we'd rather tase you than get ugly with sticks and all that. They're trained that whenever you have a taser, a less lethal, you want lethal right with it. Because if that doesn't work, you got to go to, that guy with a taser in his hand won't be able to transition as easy as someone with a weapon. So a lot of what you described in that caper is, to me, so far sounds like police training. Knives are very dangerous, and when you deploy less lethal, you're going to have lethal right with it. But what I'm saying is if the cops are trained that way, and you know what it's like, we're not there, we're just kind of guessing what it was like and everything. I guess what I'm asking is, an untrained eye might go, oh my goodness, that one's really bad, and oh my goodness, that one's really clean. And they could be right or wrong, but they might have more insight on it. And let's say that one, now a couple that you described, I have no explanation for it, you know what I mean? But the one you talked about in the hallway, to me sounds like picture perfect training. Another thing is, let's say the three of us are cops and you do something crazy. I can't testify and won't hold up in court per Granby Connor, the objective regional, that I fired because he fired. I have to justify a life-threatening attack on me or someone else to justify the use of force. I can't say because he did. And cops have done it in the past and they've gotten in trouble. You can't. It can't be panic fire. You got to individually articulate. So you got a cop with a gun and a cop with a taser, someone attacks with a knife, and they both deploy. You can't really use one against the other. They both have to justify their actions. So I'm just kind of throwing some context there. And I guess what I'm asking you is, how do you, because I'll be honest, prosecutors might not be up on training. Plaintiffs' attorneys might not be up on it. Where do we go? Because I'm all for the ones that clearly break the law and is provable should be prosecuted. And the ones that did everything they could based on law, faith, good conduct, but fear, should be defended, as ugly as it might look, if it can be proven, and wherever it lies between. I guess I'm asking you, how do we figure out, me, you, MCOs, law enforcement community, the community of the public, groups like yours, ACO, how do we work together to figure out what's a reasonable, you know, like you talked about the imaginary, the hypothetical officer standard, you know, the objective reasonable standard per the Fourth Amendment, per the Granby-Connor. You're right, it's kind of like a hypothetical. Would a reasonable officer with reasonable training and experience feel and do something similar? Not the exact same thing, but they've done something similar. That's the standard, which most people don't know. The public doesn't really know. So I'm asking you, how do we start? And believe me, I'm not on either side. I'm helping. I'm here to help figure this out.
Yeah, I think it revolves around what you just said in terms of one officer can't use the actions of another officer to justify their conduct, right? And it's not, in this case involving R. Rosser, at least for us, it's not a question about the merits of what was done or not done by those officers. It's a question of the process and accountability and public perception. What the public can know, and what many of them do know, is the objective officer standard, all right? Which is, what would the reasonable officer do under those circumstances? If both of those officers are operating with a mindset that I can't use a taser based on what he's doing, and I can't use a gun based on what he's doing, and they're making an independent judgment about how to respond to this situation, that creates a lot of questions for the public. Because which of these officers is reasonable? Is it the one who used the taser, or is it the one that used the gun? And if there are questions about the independence of the prosecutor when he's making the decision, then that creates a public perception problem. It creates a credibility problem. And the suggestion is that in those kinds of cases, where lots of questions can be raised, where the decision can go either way. I mean, it may very well be that this was an appropriate response to this woman. We don't know, right? But the public will have greater trust in the decision that's ultimately made if it's made by somebody who is not necessarily dependent upon the goodwill of the local police force. And that's really the point that we're making. You know, beyond that, and getting to the merits, not necessarily of the Rosser case in particular, but in terms of how police approach many of these kinds of situations. It involves, you know, including Milton Hall, you know, where they gunned him down, is what Chief Tolbert was talking about this morning in terms of de-escalation. You know, at the time that Milton Hall was on a rant, you know, he was screaming, he was hollering, you know, he was yelling all kinds of things. I mean, he was really, you know, acting out, all right? But he's human. And human beings get tired. And so there's a real question. I mean, I know it's Monday morning quarterbacking, but there's a real question about why the officers didn't just stand down. They said, you know, you guys, you know, you got these calls across town. You know, Officer Smith and I'll stand here and keep an eye on Milton. And they just parked themselves, because he was out in the middle of a parking lot all by himself. He was not a threat to anybody, all right? And, you know, he was content to just say his piece, whatever that was, that they sit and they just watch him. They just watch him until finally he gets tired or he wanders away. And when they find him sitting in an alleyway someplace, you know, brooding, that they walk up to him and they say, you know, Milton, you're acting like a real idiot out there. You're gonna have to come into the station with us. And then they just take him in. What was the urgency? You know, I mean, what threat did this man pose to anybody that would require them to gun him down? And so that really, those kinds of issues are what are very present in the minds of the public. And it's really hard to explain to the satisfaction of the average person how this man is dead and no charges were brought against anybody. It's really hard to explain. And then if you want to turn right around and go to the public and to say, well, you know, we need to form a partnership with the police. You need to trust them. That's a hard thing to do.
What does the jury instruction with regard to willful deprivation say? Do you know?
I don't know off the top of my head, and I really think that it probably varies depending upon what the particular jurisdiction's holding is, with respect to the statute.
They cite the statute.
Yeah, I mean, like in the circuit that follows the Screws case, then it's probably gonna contain additional language about reckless disregard that you won't find in a circuit where they really sort of discount the Screws as governing law.
Here's my concern. If someone's hunting down a wild tiger or lion, they get a gun that is going to put that lion or that animal to sleep until they can capture it. And if a wild dog is running through the street or a bear, and to this day, I cannot imagine why anyone would have to be killed for life or death, where there is the capacity to shoot bullets or guns that will basically knock the person out or take them down in a way that could safely bring them to justice. And so that's an issue that I think the criminal justice system really needs to visit or revisit, because I think there may have been some studies and discussions years ago about some other form of taking people into custody without killing them. So I just want to add that to the discussion.
Does the Justice Department ever say why they don't think there's willful deprivation, or do they just say, well, we don't think there is, and so we're going to deny prosecution? Do they ever explain why? Is there an opportunity?
Oh yeah, I mean, they've been very open and forthcoming about this, and as I understand it, it's a question of an assessment of exactly what meeting that standard demands and requires.
They think they can prove?
Right, and the inability to present sufficient evidence that would provide a window into the thought processes and the frame of mind and the mens rea, of the officers involved. Thank you very much. So, Susan the clerk from the Department of Justice. But we're not gonna put that on you.
That's okay, I don't do criminal work, so I can't answer any of those criminal questions.
Okay, we love Susan Clark.
Thank you.
So, the Department of Justice has, as I understand it, and I'm sure she's gonna tell us more, has addressed this whole question in a number of different ways and has provided a number of different opportunities for training and other ways that law enforcement agencies can begin to deal with these questions of tensions between communities and excessive force and implicit bias and other things. So I'll turn it over to you.
Thank you. Thank you. Mark is such a fantastic eloquent speaker. I always hate going right after him. But good afternoon. Thank you so much for having me here and for the great work that the ACLU does for fighting for civil rights in our community generally. By way of introduction, my name is Susan DeClercq. I'm an assistant United States attorney in the U.S. Attorney's Office here in the Eastern District of Michigan. I am chief of the Civil Rights Unit, which does solely civil rights enforcement. So none of the criminal civil rights issues that you have been talking about and that Mark was talking about. But I would like to just address some of the work that the Department of Justice and the U.S. Attorney's Office does generally with respect to police and community trust and policing initiatives, including some grants and some legal work and other things like that. We're here because for the past year, our country has been engaged in a very important national dialogue about these issues: police practices, community police trust, and racial justice. This is a very critical evaluation that that is really a key component to ensuring that our criminal justice system is fair, equitable, and transparent. So I am very happy to be here to further this ongoing discussion and to talk about the work being done by the U.S. Attorney's Office as well as the Department of Justice. Both the U.S. Attorney's Office and the Department of Justice, they do prosecute police officers for intentional misconduct, but as you heard Mark talking about, this is a very limited tool, and it certainly cannot address the complexities involved in the task of policing in our society today. So another component that the Department of Justice's work is comprised of is that we also engage in the review of systemic law enforcement practices that may be violating people's civil rights and federal rights. Under the current administration, we've been busier than ever. The department has actually opened more than 20 investigations into police departments across the country. The department's recent investigation report of findings of the Ferguson Police Department illustrate many of the issues that have created the atmosphere of distrust of the police felt by many communities of color. So, for example, the investigation of the DOJ found that the Ferguson Police Department engaged in a pattern or practice of unconstitutional conduct, such as conducting stops without probable cause and using excessive force in violation of the Fourth Amendment. The investigation also revealed very pervasive racial bias in the police department and their court system, including evidence of unlawful discrimination and racial disparities in virtually every available metric that was looked at. Although the department is not pursuing a criminal case out of the incidences in Ferguson, based upon this sort of pattern and practice investigation findings, DOJ is currently in negotiations with the city of Ferguson to reach an agreement regarding the entire police department and their practices, which has potential to bring widespread reform to that department and impact far beyond what a single criminal case would have. These types of agreements and then the work done by the Department of Justice and the U.S. Attorney's Office across the country, we hope are helping to change the way that police services are being delivered and reforming force practices as well as racial and ethnic bias in policing. At the heart of all of our recent agreements between DOJ and local police practices, as well as some of the specific initiatives put forward by DOJ as well as the President, is the concept of community policing. Community policing is not a specific program, project, or initiative. It is an operational philosophy that focuses on police and community partnerships, problem solving, and organizational transformation. It is not simply community relations or having officers participate in community activities to generate goodwill. It really impacts all the facets of police operations, including officer recruitment and hiring, the use of crime-fighting strategies, the organizational structure and operations, and then a broad range of other law enforcement practices and processes. Most relevant to this discussion, I think, is that community policing embraces the notion that trust and mutual respect between police and communities that they serve is critical to public safety and effective crime fighting. It's not one or the other. Through its work investigating police departments, as well as engaging with the various community stakeholders in each of the cases that we've investigated, the Justice Department has identified certain elements that are absolutely necessary to building trust among police and community. First and foremost, police must create opportunities for police officers to have positive interaction and engagement outside of the law enforcement contact with the community. Police departments must also commit to transparency because the more communities know about police activity, the more operations can reflect the community values and priorities. There also must be fair, consistent, and robust systems of accountability, both internal and external, to correct problems when they are identified. And then to best identify problems, police departments must engage in thoughtful data collection and analysis, which I think in many instances is often not occurring. In addition, improper bias, both explicit and implicit, they must be identified and corrected. This is done through specialized training as well as professional support given to the officers themselves to cope with the stress and the trauma that they encounter on the job. Training is also needed to better educate police officers on how to de-escalate situations, especially with the mentally ill and others in crisis. Training is needed to ensure respectful interaction between police and interactions with LGBT community, people with limited English proficiency, and other vulnerable populations. Whether someone is treated fairly and respectfully by the police has been shown by research to be more important than the ultimate result of that person's interaction. Although this is clearly not an exhaustive list, and lots of other issues may impact the relationship between police and community members, these principles must always play a role. In addition to the legal work already discussed, DOJ supports law enforcement and communities through grants and programs. So for example, this year the Bureau of Justice Assistance, which is a DOJ component, is administering a $20 million body-worn camera pilot partnership program, which will equip law enforcement agencies with the tools that they need to protect themselves and their communities. Last September, DOJ also launched the National Initiative of Building Community Trust and Justice. This is really a sort of a unique program. It's a $4.75 million program. It's begun with 6 pilot sites. The plan is that they assess the current police-community relationship in each location. They develop a very detailed site-specific plan that will enhance the procedural justice, reduce bias, and then also support racial reconciliation in communities where they found that it has been eroded. So through the department's Office of Justice Programs, even police departments outside of the pilot sites can request this kind of training, peer mentoring, expert consultation, and other types of assistance on these topics. At the same time, DOJ's COPS office is issuing $163 million in grant solicitations to support state, local, and tribal law enforcement in implementing the President's Task Force on 21st Century Policing recommendations. This task force was established in December of 2014 by executive order following the events in Ferguson and other places. They came out with some findings and recommendations, and the President has pledged that they will serve as the catalyst for the type of police force needed in communities across the country. The COPS office has also recently announced on September 21st over $107 million in COPS hiring program funding awards to nearly 200 law enforcement agencies across the country. This money is specifically aimed at creating and protecting 866 law enforcement positions. So it will give some much needed resources to many departments across the country. Finally, through the Project Safe Neighborhoods, which is the DOJ's primary initiative to combat gun and gang violence, the U.S. Attorney's offices every day work with local law enforcement agencies, research partners, and community groups in order to reduce the violent crime through strategic planning and research, increased federal and local law enforcement partnerships and outreach, as well as prevention and re-entry efforts. In 2014, more than $7.5 million was awarded to these Project Safe Neighborhood projects in local jurisdictions. So I will conclude by quoting our Attorney General Loretta Lynch, who continuously states that building relationships and trust between police and the communities that they serve is vital work. And then the Justice Department and the U.S. Attorney's Office are committed to doing their part, both here and nationwide.
So, if you want to mention
Looking at the various programs that are being created, are there any programs that have a focus toward jobs for young people in the community where, for instance, Detroit, where the unemployment or underemployment rate is so great, and so that in many communities, unfortunately, drugs do become the job of necessity for some, not every young person, but for many. And so to keep that from happening, from the very beginning, maybe programs that as young people come out of high school going into law enforcement, some tunnel or transition to that kind of work where money would be placed there.
There is some money, I think, in some programs that come out of the Department of Justice, especially with reentry work, there's a lot of jobs and sort of community reinforcements. But even before that, there are projects to sort of geared towards kids in school to try to teach them about violence and gun violence, and also to try to get them connected with mentors and peer people in their community so that they don't engage in that behavior. But I think that most of the federal dollars